I did it yesterday, didn't I?
Yeah, you did.
Morena, we'll commence the hearing, resume the hearing of PC 21. I think everyone is here, so thank you very much. Just to recap where we're at, today we'll hear from Mr. Colgrave, who's joined us in person. Thank you very much. We have submitters at 9:45, including Mr. Sanford, who couldn't make it yesterday in the afternoon, so take Mr. Sanford first, possibly, and then we have Craig Barr and Christine McMillan for Piece of Development Limited and HWR Property Limited. And at that point, after that, we'll probably go to back to Mr. Vivian just to ask a couple of questions that have cropped up during the course of questioning yesterday, and also to do some admin things, including signing a JWS master copy. And then we'll go to the report, Section 42A report author, and possibly have a closing statement from Mr. Page, which could be in writing. It's your choice as to how you want to do that. Okay. All right. Unless there's any issues to arise that anyone wants to raise now, we'll box on.
Yeah, the only thing I'd like to is that overnight Mr. Vivian has produced another set of provisions with the amendments that were discussed yesterday.
Okay.
And with a couple of the maps which will enable you to incorporate into a decision.
Right. Okay.
So you can receive that when you ask questions of Mr. Vivian, or you receive it now, yes, whatever suits you best for another time. In.
Yes, we'll probably do it at the time Mr. Vivian comes. That would be the best, I think. Yeah.
In that case, just introduce Mr. Colgrave.
Yes.
Ask him to build evidence and answer any questions you might have about the economic analysis.
Thank you, Mr. Colgrave. Yeah, thank you for coming along, and we've got your statement. We probably haven't got a lot of questions, but it's useful to have you here just to help with those anyway. Now, would you be happy just to take questions on your statement? Yeah, unless you have a summary statement, we'll just do that, I think.
Yeah,
okay.
It's a short brief, so I didn't summarise.
Okay, all right, thank you for that. Now, right, we'll go to your statement. First of all, I had a question at 25. Did anyone have a question earlier than that? No, okay. Yes, just to clarify a matter that came up yesterday and with some of the other witnesses, the commercial centre GFA cap, if you like, of 2,200, that you were comfortable with that cap, because I think there was some reference to 2,000 square metres and there was a small difference.
Yes,
is that right?
There was some small changes with that.
Right.
Well, in the sort of marginal error, so yes,
yes.
It doesn't change that.
And the GFA in the Cromwell Town Centre is 31,000, so you're saying it's a small proportion of that.
Yeah.
Okay, and while I'm on the floor, so to speak, I had a question on paragraph 26, just paragraph 26C, the spillover demand. I think I understand what you're saying there, but are you saying that by providing a commercial centre at Parkburn, it will provide facilities for the people that live there, but there'll also be a spend in the town centre, and that would help to offset any potential risk of undermining the centre. Is that what you're saying? Oh, that's amazing.
With circa 500 households, they'll generate lots of spend. Only a small proportion will be captured on site. The rest of it will sort of naturally flow here or potentially along from Queenstown.
Right. And
so it will support the town centre, not challenging.
And just finally for me, and the small centre in Parkburn, would that likely capture some passing trade, if you like, or at least tourist accommodation trade?
Potentially. It would depend on how accessible it was from the same highway. I don't think it's unlikely to be of a scale or a type that would really divert a lot of passing trade. I think most passing trade would see that the Cromwell Town Centre was 5 minutes down the road and had a lot more to offer, and people were probably more likely to go there.
Right.
The other thing about the commercial stuff, which I possibly didn't express strongly in here, is that it's the sort of thing that comes once a residential in place. It's the commercial service cycle, one of the better term, to have that stuff there before the residential. Yes. So typically you'll get a couple of the stages of residential development on site to create that critical mass. And it's only once you get to that point that it'll be economic for the commercial side to start coming on board. So, so you'll already have a forward demand there.
Right.
It's not like the commercial will pop up on day one and then full scheme from elsewhere.
Understood. Thanks for clarifying that. Thank you. That's all the questions I have. Yeah. Okay.
Paragraph 27 of your it's your evidence in chief, I believe, where you're addressing foregone quarry production. Your analysis appears to be quite qualitative from what I can see. Is there a reason for that?
I did a resource consent for another quarry just on the edge of the lake a year or so ago, and so got quite depth into it there. I guess for this plan change, the focus has really been on what's going to happen there as opposed to what we're foregoing. I did turn my focus to the foregone quarry production, but it is, I guess it is reasonably small in the scheme of things, but very importantly, having discussed this more with Paul Hogan, they've made it pretty clear to me that the sort of slowdown or loss of production there will certainly be offset by increasing production at nearby quarries, and that their plan is to find another quarry site over time as well. So there'll be a reduction in the quantity of aggregate that's produced from that quarry eventually. It'll take it'll take some years for that to happen. So there will be a bit of a slowdown there. It will be offset by production elsewhere. And Paul Hogan have sort of reassured me that the people who've got working there will either be redeployed to one of their other quarries nearby or in another part of the organisation. So it'll be more about a redeployment of that labour resource as opposed to a loss of employment. So I think when I did my initial analysis, I sort of thought, well, it's 12 jobs, $1 million wages on the table. It's since become very clear that those people will have a job elsewhere, and so that affects sort of the cancels out, I guess. The only other sort of relevant part about the quarry production, I suppose, is the sort of downstream effects of not having that production online and people who rely on it and so on and so forth. And again, having talked again with the team, it seems there is enough capacity in these other nearby quarries to pick up the slack and make sure that everything's okay. So, and they've obviously got a commercial interest in making sure their customers are kept happy and that everything keeps ticking along as well. So,
sure. So, so your final conclusion is based on that kind of set of assumptions, relying on Ms. Sinclair's evidence there.
I hadn't looked at that evidence. I wouldn't really say it's a set of assumptions so much. I guess it's just an understanding of what's there and how it's going to play out. Because as everyone in the room will know, these things have a very long lead time.
Yes.
Even if the plan changes dramatically, it'll be many years before the first house pops up. So there's quite a long period of time where you will be transition to redeploying staff and making sure aggregate customers are taken care of. It could have been possible to do a really detailed analysis of that, but I don't think that it was any significance to warrant it, especially in comparison to sort of the housing market impacts, which I think are, in my view, are more significant.
No, that's helpful. Thank you for stepping me through that. I think that's all of my questions there.
Okay. Questions?
As part of your analysis on the effects on the Cromwell Town Centre, did you speak with any of the business owners?
No. We do a lot of detailed market analysis, though, and I think if you go and talk to a business and say, well, there's potentially a competitor up and down, they're obviously going to, well, they're likely to express a slight concern. So, but I think that, again, it needs to be contextualised. I think if you went in and said, look, there's going to be another commercial centre up the road over time, will be much smaller than the centre you're part of. It will also be part of a much bigger picture where you would be creating a pool of demand that will feed back the other way. I think if you sort of provide that bigger picture, it would be unlikely that the retailer would be significantly concerned about it. But even if there were concerns, I think, obviously need to respect and acknowledge that, but also need to sort of come back a step and realise that, retail distribution effects into the RMA are quite a significant threshold test. And even if there was a small competitive impact on a single business or something like that, that would clearly be unfortunate. but wouldn't get anywhere near the threshold of sort of significant retail distribution effects and things like that. And I think I sort of take comfort from that relative scale. So we're sort of talking about 2,000 square metres versus 31,000. It's a bit of a David and Goliath fight. So it would be very difficult, I think, for a small centre like that to seriously challenge the vibrancy of the town's control at the time.
I do have one more question.
Yeah. So
We've heard yesterday from traffic experts around some of the threshold triggers that might impact the housing yield, the development yield upon certain improvements being made. Does that change or have any bearing on any of your assessment? If there were less dwellings created at certain times, by certain times?
No, sorry. I've taken a pretty big picture view, I guess, and taking a stage by stage approach. I think infrastructure triggers are a pretty normal part of this time process, and something like this would naturally be staged anyway. You don't sort of just go and provide 500 new lots on one day, and so it's very normal for these things to be staged over time. It's very normal for traffic upgrades to be triggered as things go along. So it doesn't really affect my analysis.
Okay, thank you.
one further question. You're focused on the commercial distribution, retail distribution effects, and that's understood. I noticed there's some restrictions proposed for the offices and industrial activities. There's a coverage limitation on industrial use, and offices are restricted to 20% of the net floor space. There may be for amenity and other reasons, and I'll explore that with Mr. Vivian, but is there anything there of interest to you in terms of the amount of industrial and office activity that would be provided on this site?
No, I think the industrial activity and the business activity proposed there is a natural fit with what's already happening, I guess.
Yeah.
The industrial area is south of town to very significant. And again, I don't think you'd see any sort of wholesale redistribution of activity from one area to the other. The 20% threshold, I guess, is a sort of a non-ancillary office thing, which we find in most plans.
Right.
That threshold can change between 10 and 50%. It's not less than 10 to 20%. So I think that's an appropriate threshold.
It's a standard sort of a threshold.
Yeah,
Okay.
and it's incredibly unlikely as well, because it's a non-ancillary retail, non-ancillary office.
Yeah.
It's the sort of thing that's obviously attached to a business. It's a part of the business, but it's not its key activity. So that wouldn't see the relocation of other offices that attached to the business. No.
Thank you for that answer, and I don't think we have any further questions. So that's been helpful. Thank you very much. All right, we'll now move to some submitters. Have we got Mr. Sanford here? Sorry, I haven't met Mr. Sanford. Is he here?
No, I don't.
He's not here yet. Okay, that's fine. All right. In that case, there's plenty of time for that. So we'll go to the Mr. Barr. Was Mr. Barr here today? Yeah. Oh, hello. I haven't seen you at the back there. Yeah, just come forward. Great. Right. Right. Thank you. Welcome to the hearing, Mr. Barr. We've discussed some of the matters raised in your submission during the course of questions of the proponents. So we think we understand what you're asking for, but would you like to present that to us, and we can ask some questions? We've got a statement from you. Have you got any other sort of summary statement? Yeah. Okay. Okay.
Can I have my executive summary right in front of my evidence?
Yep.
Is that page 1?
Yep.
Yeah.
I think read through that. That'll set the scene quite nicely. Yeah. Thank you for that. Yep. Yeah. Just read that.
Just before I read that summary, I'll just recap the submission from Feasibility Development Limited, and there were three key things, and the first one was access from piers and moorings to the plan change land via Pony Court. Seeking greater certainty of development outcomes, and the third element was rezoning land adjacent to the plan change area. So just diving back into paragraph 1.1.
Yep.
I support the introduction of a structured plan into the district plan and the introduction of more detailed provisions in the district plan as identified in the evidence and chief. And also is generally supported by the council's planning officer in the section 42 report. I consider that these provisions will be more effective at realising the development intentions promoted in Plan Change 21 at 1.2. The submitter seeks a 0.9 hectare area of land located adjacent to the plan change site that is sought to be rezoned from existing operative district plan rural residential area 3 to lower density suburban under PC 19. I consider that rezoning this land will result in a more efficient and practical use of that land while appropriately managing the adverse effects on the environment. The lower density suburban zoning is consistent with the zoning having sought by the requester on the immediately adjoining land to the north. And I also consider that the rezoning submission can be considered and changed and within the council's jurisdiction to consider the rezoning submission.
Thank you. Right, we'll have some questions of you. So I'll just hand over to the panel first of all. I've certainly got some, but do you have any questions?
Thank you. We visited the site, Parkburn site yesterday, and we drove through Pies Moorings and had a look at this particular piece of land. And we were interested in, there was quite a lot of, obviously some bunding there, and it does appear to be quite a narrow strip of land. So we were interested in, I guess, what can feasibly be developed there. Is that kind of how will the developer approach that piece of land?
I would say that well, so the first thing you want to do is get a geotechnical because it's there is the elevation change between the existing Peas and Moorings Township and then what dives down. And I don't know the history of the site as to whether that part of that land is sort of the surface material from Peas and Moorings was developed, or if it's something to do with probably not anything to do with the funding, sort of shielding from the Parkburn quarry site because it is on the submitter's land. But fundamentally, because there is that relatively steepish escarpment face, you would need some relatively careful subdivision design, perhaps even some fill to the north or to the south. I'd assume there'd be an access way running on the south from Tony Court, and the houses would be to the north of that access way, so we can keep tracking out there. So I assume there might need to be some earthworks to sort of create flatter areas of land. But in some respects, while it's quite a sharp escarpment and a very narrow site, I was also looking around Peas and Moorings previously and so this morning, and there's that development on the eastern side of Peas and Moorings that's on an escarpment. So it's not dissimilar. I don't think the outcome would be that similar to that, but there has been development on the escarpment of Peas and Moorings. Generally, sort of think of Peas and Moorings as you drive past it. That's generally flat and Lake Dunstan. But there is that escarpment base behind the cherry between the development and the cherry orchard. So I think there'd be a similar development to that, but those lots do have a much more sort of spacious for them, and they're orientated differently to this. So look, submission and the evidence didn't include any potential development scenarios sort of supported by agency that realised. I think that you'd sort of see that sort of development, the access way along the south, developments to the north. There might need to be some fill to support the access way to utilise that part of the sites for development. But I think without sort of restating what I've said, I think you'd probably be able to work with that better if the section sizes didn't need to be as long as what they would be to achieve a minimum line sort of allotment size under the large lot residential, rural resource 3, residential resource 3 area.
Yeah. Thank you. And the other piece of, I'm looking at figure 1 in your evidence. Oh, sorry, in the submission. There's another piece of land towards the east on Arian Court. You're not proposing that that's already zoned.
That's zoned, no, that's not part of the submission.
No.
And it's not owned by the submission.
Figure 1, the 3 properties highlighted yellow adjoining the PC 21 site owned by the submitter. So there's the big block and then the narrow strip, and then there's a little piece on the east right-hand side.
Oh, sorry, the submitter does own some property.
Yeah.
At the end, those sites are already subdivided
Yeah.
for a large lot residential.
Okay.
So the brief wasn't include that lot in the subdivision in the submissions.
Okay. Thank you.
Do you have any questions now? Mr. Barr, did your client anticipate that strip of land, if it was to be rezoned as part of 21, being part of the structure plan area, or the structure plan boundary being changed to encompass this land? Is that what you envisaged?
No, and I touched on that just lightly in my evidence.
Yeah.
No, that was considered, but because of the very small area relative to the rezone, and also the very small relative uplift in yield compared to the operative PC19 zoning, the effects from the effects from an infrastructure perspective, roading, and just general strategic integration of that land didn't justify it.
Right. And what's the yield? Is it 12 or 15 units, something in that range?
7.
So, 7, is it? Okay. Right, okay. The reason I asked that is that there are some rules that would go with the structure plan, such as, the trigger, the 271 residential allotments, when that figure is exceeded. In fact, there's a joint witness statement which now brings things forward even for less than that, but there was a trigger of 271, and conceivably if the panel included that area in the structure plan, if your client was to develop those 7 units ahead of Fulton Hogan, it would mean that you would sort of jump the gun, I guess, in terms of that trigger. It would reduce the amount of sections they could build before the work had to take place. But if it was excluded from the structure plan area, that wouldn't be a consideration. And I guess just before you answer that, did Waka Kotahi lodge any further submission, you recall, in relation to your submission? No. No, because they've been interested to get suitable mitigation before any development happens on the Parkburn site now, so that's been agreed to. But I guess your answer would be that it's only 7 units potentially, and it's certainly not integrated with the Fulton Hogan development. It's a strip of land that is probably naturally more aligned with the existing residential development. Is that right? Is that what you would say?
Yes, thank you for the answer, but fundamentally,
I think you went partway there before.
Yeah, it has an association. I'm just reviewing my evidence on whether or not the submission is on plan change, so I think there's that association. But in terms of the change, the environment and the effects of the plan change, it's relatively minor compared to the PC21 overall, and
right.
And also that I'm thinking about the overall proposed yield cap of 543 units that, to become, what's the word, involved.
Yes.
I'd see it as more of a complication than an integration.
Right.
This site, and because the site also has this existing frontage of Tony Court, while that portion of Tony Court's not formed, it could be developed if the rezoning were to happen by, fundamentally litigating off this plan change process, and not being associated with the structure plan. The obligations under, giving people the structure plan aren't the same for this landowner, a landowner for the subdivision rather than PC21 site. But that said, the effects on the environment are commensurately low as well. I think the reality would be is that Coney Court probably wouldn't be developed. And this site would be rezoned until fundamental things were happening as part of the PC21 subdivision and development as well. So yes, you did sort of answer that question for me, thanks, Commissioner, around it being very low yield relative to it and not needing to become part of the, I wouldn't say complications, but part of the planning considerations for the giving effect to the structure plan.
And in terms of timing, at present there's a bund and then there's a quarry on the other side of the bund. And if we were to agree to rezone your strip of land and keep it separate from the structure plan, could there be a reverse sensitivity issue with creating 7 new houses at the base of the bund when there's currently dust mitigation things in place and that sort of thing? Is that something I mean, it's all about timing, I guess, but to rezone it straight out would allow that to happen, development to happen straight away, potentially, if it wasn't part of the structure plan requirements.
Yeah.
I mean, another option is to actually apply for your own rezoning plan change at a later date. I guess that's another thing.
Yes, the submitter had an opportunity just recently through PC19, but in that context of PC19, that's only fits the surrounding neighbourhood, and with the introduction of PC21, it's an opportunity to revisit, I guess, developed urban land that's right next to it. But just on the question of reverse sensitivity, the Park Inquiry has consents and it's a scheduled activity. It provides a hard-nosed answer around people being aware of what they're moving, the environment that they're moving into. But the reality is that people are there and they have a problem. They have a problem.
And if I can just ask, now, does the scheduled activity provide any protection for neighbours, or is it just basically a confirmation that this activity can proceed pretty well?
Confirmation. I don't think we can challenge the legality of the activity if they were suddenly annoyed by it.
No, I mean, in terms of any mitigation or any rules, would they apply, or is the scheduled activity?
No, I think the scheduled activity you're right, and I haven't dived into the resource consents and their obligations around mitigation.
Okay.
I think I'm not a resident of Peas and Moorings, but from what I can see and from what I understand, I think that it appeared operating relatively harmoniously in terms of that, development inquiry.
All right, no, that's all the questions I have. So thank you for, unless there's anything else you wanted to clarify, but we understand the submission, and I think your arguments about scope, I think there is potential scope to include it. I mean, I don't think it is a contiguous piece of land and it's a fairly minor extension potentially. So from what my experience in dealing with these matters, I think it can come within scope. It's a question of whether it's appropriate to rezone it or not. But it's possibly a legal matter, but I think you've traversed the correct tests in the Act. So I think that's good for us to be able to consider that. Okay, thank you very much. No further questions here. Thank you. Right. Oh, well, Mr. Sanford. Yeah, thank you. You can come forward now if you wish. Thank you for coming along. Thanks, Mr. Sanford. Sorry we couldn't stay long enough to hear from you yesterday. Yes, that's right. Yeah, that's right. No, that's understandable. And we've got time. We've got time to consider your matters today, so that's fine. Now we've got your submission in front of us and the statement that came with it. So it might be useful for you to just give us a précis of what your concerns are, or what your points that you're making, because you're basically in support of the proposal, aren't you? Subject to certain things happening. So we're in your hands if you present that to us.
Yeah, give you a bit of background on myself as well. I've been living in Peas and Moorings for 8 years now. Probably about 250 metres from the park and boundary. Dust has never been a problem for me because of where I'm actually situated, so you have to go elsewhere. But yeah, this this is an opportunity to turn it into a residential development, and I think it should be taken. I'm a licensed surveyor, I've been licensed for over 10 years now. And locally, I've worked from concept to completion, basically, Prospectus Park, from lot design right through contract and construction management, project management, through the land survey titles and stuff. I submitted on land change 12 in support of the wound tree, on the basis that 4,000 square metre sections was inappropriate. Submitted against land change 13, somehow missed the vote on land change 18. And here I am now, and I've heard myself with land change 19. So I try and keep above these matters, albeit that I'm not a planning scholar, playing licensed survey. So I guess my submission is that just to talk to the 3 points really is the road access at the end of Pony Court is pretty critical moving forward. There might be 2 steps further to actually get a road constructed through there. There might be third-party dependencies, but with the parkland plan change, I find it absolutely critical that parkland does all it can to get road access to that area, so the road can be built, regardless of whether it's dependent on third parties. Obviously, Peter Moyes has inlets already. You probably wouldn't choose to swim in some of them. I can't tell you what the answer is, but as long as someone's thinking about appropriate infrastructure or ways of maintaining and cleaning those new proposed inlets, that's what I'm after there, as long as that has been thought about. And now I'll speak to my further submission, which basically took aim at Wakatahi and Ministry of Education. The Wakatahi submission it raised quite a few points, basically in support of the plan change, but ultimately opposed it. It went around in circles, it didn't really have an aim. And if you look up the definition of frivolous, I think it doesn't really detract too far from that. And I don't know whether that submission should even be accepted because it raises a few topics, but doesn't really address them in a way that really opposes the subdivision, albeit that they've concluded that it shouldn't go ahead. And then they tried to put the showstopper in your climate change. I think residential developments anywhere inland is probably a good idea in theory, if we're going to keep that discussion high level. I think you might have just been talking about that lot 16, 514674 to be rezoned to low density residential. You obviously discussed that in great detail, but what I'd just say there is that Cromwell's far too busy, Petermore's far too busy now to have wasteland trapped between other appropriately zoned land. So there may be reasons, there may be legislation, there might be something that stops that from happening, but I would urge you to look for opportunities to ensure that we don't have wasteland trapped in residential areas. And as for the Ministry of Education, I mean, I see it as their role to respond to growing populations. They obviously weren't happy, they weren't consulted. If they were consulted, they'd probably say no, because you have to build extra classrooms. So,
yeah, Mr. Sample, I probably should just update you. The letters come in from Ministry of Education and they say that they're now satisfied with their concerns are being met. So
yeah.
they've essentially, they're not proceeding. So the points you make are valid. I think that they've said they're happy now. Yeah, okay.
That's good news for everyone.
All right. Thank you.
That's about it. That's, unless you got anything else you want to query me on about my submission, but overall, it's a great opportunity for our basin. It's a good spot for land development, and it'll complement the existing Petermore's village really well.
Thank you for that. Yeah, no, thank you for that. proponent has picked up on some of the points you've made and addressed those with including some further assessment matters, so that when this goes ahead, when the land's developed, those matters will be taken into account, especially the roading and access, but other things you've raised as well have been picked up in the assessment matters. So I think that's a good contribution. So thank you for that. Any questions to go?
No, just really, thank you for coming along today. Not so much a question, but just to provide some reassurance to you about the Pony Court connection that's now shown on the structure plan.
Yeah, cool.
So that appears to be moving along. I understand from the applicant that there's been some agreement with that third party.
Yeah.
So yes, so that hopefully reassures you that that connection will be provided.
Yes.
Yeah. Do you noticed in your submission you had a point about cycle trail access? Do you still pursue that point?
It's not major, but at the moment, I know it's great to integrate the new development with the cycle trail, but in saying that, it's not direct cycle trail too far into however it's going to cross that, isn't it?
Yeah.
And keep it relatively superficial out near the lake.
Yeah.
It's just a thought that certainly not deal breaker.
Yeah, we heard yesterday from urban designer and also from Mr. Vivian around accessibility and those connections, and we've had the reassurance that that can be provided.
Yeah.
So yeah, that should speak to your concern there.
Yeah.
Right. Thank you.
Just got one question.
Yeah, sure.
You mentioned that your further submission about plan change 21 proposal standing to improve the currently one-dimensional urban form of Pies and moorings.
Yeah.
Are you able to just elaborate on that a little bit?
It is one-dimensional. There's houses pretty much. I live at the north end, as I said, probably about 250 metres from the boundary. There's the Moorings restaurant and I can't remember its name now, the hotel complex down the south end. Apart from that, we've just got houses. We don't even have a corner shop or anything. So any development that provides something a bit more interesting, like commercial or retail, something different to residential would be good. And it's also really one-dimensional in the fact that it's 1,000 square metres, except for what was RRA 11, I think it was, which was 800 square metre average, where the old vineyard was. It's great to have a spacious section, but those days are gone. We need to be developing a bit more efficiently with the open space we have.
Thank you. Thanks, Mr. Sanford, coming on. Thank you. Right, we'll now go to Ms. McMillan. Come forward for HWR property. Thanks for coming to the hearing. We've got your statement of evidence and I've got. I'm just seeing how long it is you're welcome to read it if you wish, but equally you can just hit on the key points, whatever you prefer. Yep. Fine. Yes, that'd be good. Thank you.
So HWR just their own land adjoining to the north of Cartgrove, so they're the adjoining sites, importantly the site from the highway to the lake. HWR are basically supportive of the plan change 21, but with just some minor amendments. So at the moment the entire north boundary is to be zoned industrial. HWR are considering the end of life for the quarry area as well, and want to ensure that there is, well, most likely the next phase of use for that site will be urban development as well, subject to separate bank and more process and those things. They'd like to enable connectivity between the two sites. That's the main thrust of their submission. One of those is through road connections, so that's extending the easternmost road connection shown on the structure plan to the north boundary. We're not quite sure why it's truncated, but just extending to the north is straightforward adjustment to the structure plan. And then the main thing would be to enable some connectivity to residential use to the north by establishing either business service area or residential service area at the lake. otherwise, in future development will be completely separated by industrial use, which is not particularly great interaction between two urban areas. And then the third minor issue was just on potential inverse sensitivity. I agree with Ms. White's submissions that evidence that the industrial zone in the structure plan as it stands actually provides suitable mitigation for inverse sensitivity in an appropriate buffer zone. But if there is some change to the structure plan which allows residential business use through there, then it may end up with some reverse sensitivity effects, in which case adding in the matter for discretion, which is proposed in plan change 19 into the current plan, because plan change 19 is still unapproved. Just that would deal with that matter.
Okay, thanks. That's a good run through. Thank you very much for that. We'll have some questions. Just trying to work out where to start with that. Probably the first thing I'd just ask before the panel members ask other questions is the scope of the relief you're asking has been questioned or challenged, at least by the proponent. In terms of the submission that was lodged by HWR, it did refer to future-proofing the boundary, and I've just noticed that we've got it in front of us that the request is to future-proof the boundary to support future activities on the quarry site. So that's the context. But then in the specific relief, and that's in paragraph 11, the future proofing is to be achieved by road connections to the northern boundary by mutual agreement. In other words, there's interconnectivity between the two blocks of land, road connections, and infrastructure connections to the northern boundary. So roading and infrastructure. But what's been drawn to our attention is there was no actual request to rezone or to change the zoning of that land from quite a significant rezoning, actually, from industrial and commercial to residential. So have you got any comment on whether you think there's scope to pursue this?
I believe so, you agreed that it didn't go into that detail about rezoning, but I think the submission overall did talk about the inward, the development being inward focus. Right. In providing connectivity. It was written by a layperson before we became involved, so it's more likely to be more just an omission of a bit of an oversight really in what she was trying to achieve. But the submission overall does discuss that they don't want to see the park room or plan change 21 being too inward focused in considering connectivity and future development to the north. So. Okay. I take your point, but I do think that was covered by submission adequately to the in scope. Yeah,
it's not a point I'm making. It's just relaying to you what was put to us, and we'll have to consider that. But so that's your answer. Okay. And in terms of the particular piece of land, which I think we've got on this map here, the piece of land in the northeast corner, what's your understanding of what's on that? I mean, we did a site visit yesterday, and we think we know what's there. But what do you understand is on that piece of land at the moment?
There is an industrial activity there at the moment, and what we have shown, we're not quite sure of the reasoning behind extending industrial zone to the lake edge. Right. I think it's 5 over land that we get as residential use. Right. But there is industrial land down there and just quarry area as well. Yeah, because
we've certainly had evidence that the Fulton Hogan wish to relocate some activities from Alexandra and other into that area, or generally into the commercial and industrial area, and there's other activities, industrial activities in that area. So for that to be rezoned to residential would mean displacement, I guess, of those activities, or at least the opportunity lost for that their vision, which is to relocate activities and centralise them there. That would be one implication of rezoning to residential. Another one might be to have reverse sensitivity issues in the short term, until your client's site is ultimately developed for residential. There'd then be another boundary with industrial to the north. Would that concern you from a planning point of view to have that potential effect?
Sorry, so you're saying if they shifted industrial activity into that?
No, if we were to accept your submission to rezone it to residential, yes, you would then have an interface with existing quarrying. We haven't heard evidence about when your client intends to, develop that land for residential, and it's possibly some way off. So there could be a short-term, admittedly, this development is to go south to north. It might be some time, but before that was developed for residential too. But it's sort of into the future, and it could potentially be a reverse sensitivity issue. But I suppose the main impact for the proponent might be that's not part of their structure plan. It's not part of their master planning for the site, and it could be quite a radical shift for them to rezone this to residential. So, would you acknowledge that's an issue for them? Yeah. Yeah. Okay. All right.
In terms of the reverse sensitivity, I think that's why it's used as that matter of discretion in the operative plan and through the plan change 19 that's already proposed. For any subdivision, you have to consider effects on of existing industrial activities.
Right. Okay.
So that would resolve.
That would resolve it, you think? Okay.
So I think that on the HWR property side, there is trees down there actually, so there is a little bit of a buffer zone anyway. So, and HWR will be considering how they continue to operate that site going forward. I think you're talking about a 5-year life left on the quarry around that area. So, yeah, certainly there is potential for reverse sensitivity, but I think including that discretion will resolve that issue.
All right.
In terms of just being a major change to the structure plan, completely agree. But I think it could be beneficial for both parties. Having residential or business use on the lake end of the site seems like a really good use of that high value land and high amenity land. So yeah, benefits for both, I suppose.
Okay. No, thank you for that answer. I've got no further questions. I'll just check if the panel does have any questions.
I was just interested in your client submission. You mentioned that it was written by a layperson. What's Sue Hill? What's her role in HWR property?
She's a property manager.
Property manager. So quite an informed perspective. Yeah. Most of my questions related to the noise sensitive introduction with your proposed zoning and the reverse sensitivity, but I think they've been well traversed with the Commissioner. So I'll leave that there. Thank you.
Sorry, jump again.
No, good.
All right. No, thank you for coming along, Ms. McMillan. We've got no further questions. Thank you. All right, how are we going? Okay, right. I think we're at the stage where we've covered the submissions, and we were going to just ask Mr. Vivian some questions. So we'll just take a couple of minutes to get organised. Sorry, come forward, Mr. Vivian, and that's 115.
What I'm going to do is to hand that.
Oh, yes, that's right.
For your team, Mr.
Yep,
Chairman.
thank you. Yeah, very good. The files, I guess. Oh, it's good. Yes. Right. Yes. So, just trying to think, what should we do? The cycling one first?
Yeah, might as well.
Yeah, we've got, before we get to the provisions, we just had a question about cycling connections, and I'll ask Commissioner Cleveland to answer that.
Thank you. So we've heard that the cycleway linkage is achievable and that the applicant intends to provide for that. We've seen it loosely shown on a connectivity plan, but note that it's not indicated on the updated structure plan. Is there a reason it's not notated, and is there a way that we can notate that on that structure plan to provide that certainty?
I guess the risk of showing it on the structure plan is that it will significantly compromise Well, it'll complicate, what the structure plan looks like. So how I prefer to deal with it is, through the assessment matters on, or the matters of discretion on 7.18. This came out of the joint witness statement, 18C, that each stage of the development has internal access to the lakeside trail. So NZTA didn't want residential to start developing, people have to ride their bike down the state highway to connect onto. So this matter of discretion ensures that at each stage, those connections flow through to the trail, so people won't have to walk or ride on the state highway.
Right, and when you say it complicates the structure plan, the notation for the road connection to Pony Court, for example, doesn't overly complicate visually. So why would it overcomplicate a structure plan?
I think because the structure plan identifies quite extensive areas of open space. So all of the white areas on the structure plan are open space. So in theory, they could all be walkway, softway connections.
I see.
And then there could be footpaths next to the roads, and there could be other linkages through the zone areas.
So it could be numerous and multiple
Yeah,
notations.
yeah.
Okay, I see.
So without
Yeah.
actual subdivision design, I think it would be very difficult to show at this stage.
Okay, and what was the assessment matter you referred to there? Is this in the bundle? Could you?
Yes, I'm in the bundle on page 718.
Oh, turn to the exact right one.
So 18, the
18C.
yeah, as I say, they came out of the joint with. So.
I see, yeah.
Yeah.
Right, and so you're satisfied that you're confident that that will achieve?
Yeah,
Those
well, I'm
connections, yeah.
confident that
Yeah.
we'll pay and going to that.
Yes.
That just makes sense to link any residential to that baseline trail.
Okay, thank you, that's very helpful.
Okay. Right, so thank you for providing this consolidated set of provisions, and I've got a couple of questions, but did you want to say anything about those before I do that?
Well, what I've done is I've taken my primary evidence, my proposal evidence, and the joint witness statement.
Oh, I see.
All into one document, and just covered with blue, taking all the colours out of it. It's pretty confusing. Attached on to the end of chapter 7. On page 743 is the structure plan.
Oh, okay.
And that is the only place where the structure plan occurs in the district plan.
Sure.
And then the last 2 pages of the bundle, these essentially are the planning maps, but they're not, they don't look like the CODC planning maps. I've just covered them in, so it's,
I see.
so you can see what they're asking for. So the first one is the zoning of the offshore plan, the residential, business, industrial 2 and 3. And then the second plan, the last page of the bundle, is in the scenario that PC 19 has been released before PC 21. So that is showing the 2 residential zones sought under PC 19. And I've also attached that as future growth overlay, which if Ms. White's recommendation, her final recommendation, is adopted by the committee, then that future growth overlay would effectively replace
10:29.
Yeah, effectively replace rule 14 on page 739.
Okay.
Is that correct?
Yeah, okay. What I'm going to ask is if we do get a written closing, if this could be encaptured in writing, because I think I understand that, but it's likely that when I go and leave this room, I won't fully understand that. So, and I'm scribbling notes down, but I'd rather that was spelled out to us. And I don't think we need another statement of evidence, but it would be useful to have that clarified. I think the officer might understand it better than I do, but yeah, but thank you for doing that, and it'll make our life easier when we come to deliberate. So thank you for that. All right. Okay. I've got a couple of questions, and I apologise for going through some things that you'd already dealt with yesterday, but I've been through the other track changes, and I think I've still got a couple of questions. So hopefully there's not something that I've missed with those. But the first one was residential, page 714. So 714, and that's the restricted discretionary activity rule 733 C, and it's where you've introduced the Parkburn area rule, and that's the trigger, if you like. Oh, no, it's not the trigger. It's the cap. It's the cap of 543. That's right. And I note also an improvement is that instead of referring to the Parkburn area, there's a specific reference to the structure plan area. So that's tightened that up. I mean, the title doesn't say that, but in the rule it does. So I think that's okay. But what I was going to ask you was what happens to the activity status if that rule is breached? The presumption is it would go to non-complying, but when I went to the non-complying rule, which is some pages on, it just refers to standards and it doesn't refer back to that rule. It refers to
So the
727.
the right hand column.
Yeah.
This particular rule falls under subcapital C. So breach non-complying activities C.
Oh, so it's caught in the existing rule above. Okay. So then it goes to 735. Yep.
Double check that.
Yeah, I'm not sure.
Given agreed by non-complying activities.
1B, no, I don't think it does. Yeah. Okay. Because 1B is the subdivision rule, isn't it? I think it needs to refer to 1X, which is Parkburn. Yeah.
So number.
So I think that would just be
Yes.
cross-reference to 1X. Yeah, so
that just needs to be added into that cross-reference.
yeah, and then that becomes non-complying then. So that was the only thing I picked up in residential. But I was going to ask something about industrial too. So, industrial, sorry, 911. Oh, yeah, the other one is the industrial chapter 911, page 911 on that. And that's where there's been some new standards, I think. Some new standards we talked about it briefly with office space, 20% and building coverage and so forth. And they're all specific to the Parkburn area, obviously. Yep. And I was just going to ask, are they related directly back to the policies and objectives? And I think there are some new policies coming in, they're proposed to come in, which appeared on the face of it to be amenity things. Right, so is that what was intended, so that the coverage is amenity, the office space is amenity?
Not so much amenity, I don't think. It's more to do with making sure that, well, what I was trying to do is make sure that the industrial zone at Parkburn essentially stays based. we naturally industrial zones through the research consent process turn into business zones. And then industrial, yard-based industrial activity reports out of them. And we see that in Queenstown, and the guys, and probably starting to see it, and from all here in terms of the types of businesses that are starting to locate here. So,
right, okay.
So the restriction of the office space to 20% is primarily to ensure that it stays yard-based industrial.
Yeah, that's certainly captured in the policy 9.26 that they stay yard-based.
Yes.
And the explanation talks about recognising existing yard-based industrial nature of the area, ensure that it remains that way. So those rules or standards relate back to that intention. Okay, no, that's clear. And I did ask Mr. Colgrave about the 20% limitation on office space, and he said that's a standard sort of district plan rule to keep a limit on that. But that was the one that I thought may not have been captured by the policy framework, but I think you've answered that. Thank you. All right, now look, that makes sense to me now. Thank you very much. I don't know if we have any further questions. No, in that case, we'll just manage to get a signature on the JWS. We might as well do that now. That the reason was the signed copy yesterday had been photocopied and the fonts and colours hadn't come out, so it didn't show the changes that have been made properly. So this one does. Yeah.
I was looking through the JWs and it says the attendees for our Helen Boyd's EPA planners.
Right.
It's Kelly Watson and Caitlin Kelly.
Yeah.
But only Helen has signed it.
Okay. Right.
And I asked them why this morning, and Helen's the only one with delegated authority to sign it.
That's okay.
So,
yeah.
Are you happy with that? Or?
Yeah, we've been in touch with them since through an email to confirm we have no further questions and that we understand their position, and they replied. So I think that's taken care of. Yeah. Okay.
This one's clear, it's like it's just in case.
All right. All right. Look, thanks, folks. I think we've now got to the point where we'll take a short break for a cup of tea, and when we come back, we'll go over to Ms. White for her response to the matters she's heard during the course of the hearing, and we're getting towards the end of it, so that's good. We'll take a break for 15 minutes. Recommence the hearing, folks. Now, I think, Ian, did you have a question that you wanted to ask at the stage before we start with the officer? Yeah. Mr. Vivian, wasn't it? Yeah. Oh, those you were too. Okay. Shall we wait till we get to that point, or do you want to do that now? Do it now if it's on your mind. Okay. Thank you, Ms. White. We're just having a discussion about when to ask you a particular question, but I think we'll do it now. Yeah. So yeah. It relates to earlier discussion, isn't it? Yeah.
Yesterday, Mr. Vivian had mentioned about inserting a future growth overlay for the business and industrial zone. Are you able to comment on that?
Yes, so my understanding of what Mr. Vivian said was that because the plan change 19 is concerned only with the residential, what's currently the residential resource area, but the residential line. Then assuming that that's adopted through plan change 19, it could only really be applied to the residential portion of what is sought. So because you couldn't apply it to the business and industrial areas without making subsequent changes to the business and industrial chapters, which is beyond the scope of plan change 19. I think that's my understanding of the rule drafting that Mr. Vivian has proposed is that the way that he's proposed that through this rule drafting is into the operative plan, so to the residential resource area, is through a rule that achieves the same outcome as the future growth plan. And that rule in any case only applies to the residential or to residential development, I think is the. So it has the same effect as if you apply the future growth overlay. And then I note in the bundle that Mr. Vivian since provided this morning, that very last plan that he highlighted to you has actually been
shown, assuming that PC 21 and PC 19 are adopted, and you have to do that merger together of the PC 19 provisions. That is how it will be picked up. So the future growth overlay would be applied only to the residential portion of the site. And therefore that would negate the need for that specific rule that Mr. Carey Passer and Mr. Billion has drafted in section 7, because it will be picked up through there. But it's really, the outcome is the same. It's just the mechanism used, or the drafting mechanism used between what's currently section 7 versus what's used in the PC 19 provisions will change, but the effect will be exactly the same.
Thank you. Thank you. All right. So first of all, thank you for providing a very thorough and good report for us. We really appreciate that. And we're in your hands. I think rather than us asking you questions, and most of those have been resolved through hearing from other witnesses and answering questions. If you want to just tell us what you've picked up through the course of the hearing and any particular issues, and then we'll see if there's any follow-up questions to come from that. Is that okay?
Yeah, so I think there's 3 things. One is there's just a couple of corrections or additions to the report.
Yeah.
And then I think obviously my report came out and then there was the applicant's evidence, committee evidence, and the applicant's rebuttal.
Yeah.
And so I've just got a few comments on those.
Sure. Yeah.
And then lastly, I think there were quite a few things raised in the questions yesterday and this morning that I think I can provide some extra assistance on.
Yeah.
And then hopefully that
Yeah.
answered all your questions.
No, that'll be good. And if I can just ask that you go reasonably slowly, because there'll be people scribbling down notes and things as you go. So yeah, just take your time with that. Thank you. Yeah.
And so the first thing is just a correction. So in paragraph 86 of your main section 45 report, I recommended an additional matter of discretion around retrofitting, which was discussed yesterday. The correction is that I omitted that from the section 7 changes in the appendix. So the appendices to the section 42A report didn't include that addition. That has been picked up in any case by Mr. Vivian.
Right.
So
Okay.
the fact that I've omitted it doesn't matter so much now, because in the version that you've been presented, that's encapsulated.
So in the bundle. Okay. Thank you.
The next thing I just wanted to sort of expand on, having read some of the evidences in the 42A report, I think hopefully you can tell that the thing that probably taxed my mind the most was this question around, is this the appropriate place for growth? So having established that more capacity to apply, is this still the right location? I think there are 2 things that have come up. So sorry, I expressed that while I thought it was finally balanced, I thought that it weighed in favour of granting the plan change. And I listed some factors, but there are just another couple. So it doesn't change my conclusion, but there are another 2 things I think that become more apparent to me through the evidence. The first one relates to what I hadn't included in that discussion, was the fact that this is an existing quarry and it rehabilitates that quarry. So while quarrying, I suppose, is a productive use, but it's a finite productive use, and so at the end of the quarry's life, it's going to have to be rehabilitated. And to my mind, that distinguishes it slightly from another, if you were expanding somewhere else and you had an ongoing productive land use that you were then effectively taking out. So to me, that adds in favour of this proposal as well. The second thing which I hadn't appreciated was in Ms. Cynthia's evidence, which is just around, I guess one of the things that I had weighed up was we are adding population in an area that is slightly remote from the main commercial centre. So there's obviously that additional traffic movement. But Ms. Cynthia's evidence, I guess, pointed out that one of the advantages of this plan change would be the ability to consolidate Hilton Hogan's operations where they're currently in Alexandra, And therefore you have a reduction in that sense because you have less. So that's something I think that I hadn't really picked up on. So it doesn't change the conclusion, but I guess I just wanted to acknowledge that those two things are also factors that I think lie in there.
Okay, thank you.
So then, in terms of the evidence that was lodged since the Section 23 report, so I've obviously read through all of those. And having read Mr. Vivian's rebuttal evidence, I think, in the essence, my view is the same. I came to the same conclusions around that evidence is needed. So in terms of where he's responded to submissions and said that he thinks they are outside of scope or there is a need to add a matter of discretion, whatever it might be, I've essentially came to the same conclusion. There's only one exception to that, which is just in terms of the fire emergency New Zealand table statement. So my view remains that the matters that they have raised are not specific to this site, and they're really concerns that I think they have about how the plan provides for those matters in any case. And so my view is still that they are better addressed through a more wholesale review of the plan provisions rather than applying I think Mr. Vivian's recommended some matters of just reading added. My view is that that's something that's not specific to the site, so it should really be about looking at it across the plan as a whole, which is outside the PC21. So my preference would be to not include that as a discussion, but it's a relatively minor.
So we'll just ask you questions as we go. It might be the best way to do it, but I suppose the first sort of reaction is what is lost by doing it, other than providing an inconsistency internally within the plan? Is that what you would see, that special provisions made here but not elsewhere, and there doesn't appear to be a reason to do that? Is that what you're saying? Yes,
and I also think that in my experience, that's sort of but it's a personal preference. I think that's better considered across the plan as a whole rather than starting to introduce it in certain areas. I think it once you've got it for one area, it then is used as an argument to say this should be applied in other areas, but parties that might actually be interested in, so it becomes a precedent. And then other parties who might say, well, actually, I don't agree with that line across the board, sort of won't necessarily get involved in that discussion in terms of PC21.
And is there a current gap in the plan in terms of, this is fixing something that should have been? I take your point about having an all-encompassing review, but is there a gap at present?
I don't know, is the short answer.
Okay,
what I'm probably not particularly clear about is to what extent it might be addressed in the council's code of practice subdivision in any case, and I don't know.
All right, no, I understand that. Is there any questions on that? No, I understand the point. Thank you.
So just in terms of the HWR evidence, so I agree with Mr. Vivian that scope. And I think we also touched on that there's some other impacts that need to be addressed, like with new sensitivity and how that's managed. The other two things I think that so setting scope aside, sorry. There's no assessment of impact that having that business resource area would have on the Cromwell Town Centre. So you've got Mr. Colgrave's evidence around the scale of the business resource area in the rural package and why in his evidence this morning around why that doesn't detract from the Cromwell Town Centre. But there's no evidence in front of you in terms of if you were to rezone that additional area of business resource area, what would the impact of that? And similar, if it's own residential resource area, then that cap of 543 then also comes into play in that area. And I think, although the master plan doesn't obviously form part of the district plan, it gives you an indication of how that 543 could be distributed under the zone rules. And so obviously if you have an additional area, then it reduces the rest of so there's no kind of assessment of what that means and what happens potentially with the additional land. So that's, but again, I agree with Mr. Vivian on the scope issue in the case.
Okay, thank you.
The next matter was just in terms of the statement. So I was invited to join that discussion, but I wasn't able to be involved. However, I was circulated a copy of the draft witness statement following that, and I provided some comments. So just to confirm that that has been incorporated in the final version. So I'm comfortable with that. So I'm obviously not a signatory to it, because I wasn't involved in the discussion, but just confirming that the comments that I provided have been taken into account. So I'm comfortable with what's being added.
In terms of the rule mechanics and how it works, is you're comfortable with the language and the
Yeah, so, so without going back in history, some of my concerns were basically not with the principle of it, but how it was being given effect to through the drafting. And so the revision of that, which is in the final, I'm comfortable with it.
Okay, thank you. I think that's useful. No, I hadn't quite picked that up, so thank you for telling us that. We'll roll in it.
I probably complicated things. I think that's why there's 3 versions going around.
Okay, thanks.
So then another thing, just to, I guess just to provide a bit of clarification, obviously in the minute you asked about the plan change 19 and plan change 21 interface, and obviously there's quite a lot of discussion with the page on there.
Yeah.
So the only thing I wanted to add to that is that I did discuss with Mr. Vivian when he, in November, when they updated the application to I had a discussion with him about whether similar changes should be made to the PC19 provisions to sort of effectively say this is what it looks like and this is what it looks like. But as Mr. Vivian pointed out, the potential issue with that is we've got the only version really to make changes to is the notified version, and obviously it's likely that that will be changed through the decision, so then it becomes quite inefficient to add rules to a document that is likely to change. So just from an efficiency point of view, that's why there's only in effect one set of rules. But just reiterating what Mr. Page said, which is that should the PC19 decision be released before the decision, and therefore you would like to see what does this look like, how does that translate into the decision version of the PC19 provisions, I think that that's there will be a reasonably straightforward translation, and that's something that Mr. Vivian and I could collaborate on and provide to you. But that's why it hasn't been done as yet, because it just wouldn't be efficient.
Because thanks for raising that. It seems likely that we would have a draft decision on 21 before 19 comes out, because we have to be conscious that it needs to be reported to council, which takes weeks if not months, and then there'll be an appeal period. And so my intention, our intention is to have this one resolved in terms of the material in front of us into a draft form anyway, and then we would then park that and see how it fits into the timing. But so on the scenario that 21 has a draft decision ahead of 19, would you have any comment on that in addition to what Mr. Page said to us? Is that I think what he said to us, we should then liaise with the people who are coordinating 19 to see how deliberations are going with that, and to see how our draft decision might be incorporated into the 19 decision, if I understood it right. If you have any thoughts on that, it's a process thing really, but
the short answer is no. But
no, okay, that's right. But
the main thing is that I think that assuming that this is granted and that PC19 is generally approved, not before, it's really just about marrying the two.
Yes.
So I don't have a particular view as to timing and what comes first. I think it's more just making sure that the two are eventually merged.
Yeah, no, thanks for that. And we'd invite Mr. Page to, in closing, to just assume that 21 would probably be ready before 19. It might help with your advice to us as well. All right, thank you.
So then there are just a few matters that have arisen, I think, as a result of questions.
Yeah.
One I think was already picked up, so that in terms of rezoning the strip of private village,
Oh, yes.
that was discussed this morning by Mr. Barr. And I think you already picked up on this, but obviously for the triggers to apply to that area, it would have to apply, it would have been real in the structure plan.
Yes.
Oh, the only other thing is just, I think you asked this morning about the review sensitivity.
Yeah.
In relation to that, but I guess just a reminder that that is already zoned residential.
Yes.
So what's being sought through the submission is that it's zoned for slightly higher intensity
Oh, okay.
than the current zone, as opposed to,
Yes.
say, a rural change. That
Right. Okay. All right.
the other thing that came up, another thing that came up yesterday was just the relationship between the master plan that Mr. Baxter put through and the zone provisions, and the zone provisions now include the structure plan.
Yes. Yes.
So just to be clear, that I've been focused on the actual zoning and the structure plan and the assessment, and some of the questions that I raised before the second 42A report, which were then responded to in the update, were quite focused around that, ensuring that the assessments were on the potential envelope of effects from the zoning, not on a specific plan that was applied to the pavilion.
Right.
So I think just being clear on that, my understanding is really the master plan is an example of how those provisions might be translated into a specific development, but obviously it's not tied to that. And I think the only thing I just wanted to emphasise with that, I think is only one of Mr. Beck, was it points reviews, which I think was my last one we talked about, which is his attachment E, but it has some different densities.
That's right.
So it's just being clear that those are not densities that relate to the zones in the district plan, but they are within the range basically that the district plan would anticipate.
And I think he used those to help with yield, I think, didn't it? Is that
Yeah.
right? In terms of
So I guess the point that I'm making is that the final subdivision might have those, we might still have those densities, but they could be in different places because the zoning frameworks. It doesn't make a difference. It was just, I suppose, being clear that it's the plan provisions that I've been considering rather than any sort of more specific.
I think.
One of the other things that came up yesterday, so this is to do with, so in Mr. Vivian's evidence at his paragraph 36 is the discussion around, so this came up yesterday around the possible waterway feature in the zone. So I do agree with Mr. Vivian about if that wasn't a water feature, the delineation is there's more open space. So I'm comfortable with what he said in response to my comment about that could be developed for residential. So I'm comfortable with what he said. The other question that got raised is what other zones had he considered? So in the Central Otago district plan, there isn't an open space zoning, so that option is not here available at the moment. My understanding is that a number of parks and reserve type areas are zoned to have a residential underlying zoning. And then I think some are either dated or scheduled. That's how that functions, but I would say that it would be consistent to apply residential zoning at this stage in terms of the zoning. In the future, once it's developed, there is that opportunity to consider, particularly if it's used to become feasible, so you can use a similar mechanism, but I don't think it's actually at this stage, so I'm comfortable with that residential zoning underlying zoning. I had a note that there was a question about the zoning and what was being sought, and I think that that's largely been probably clarified through the attachments that Mr. Vivian has provided this morning. That is, the zoning that was sought was an attachment C to the request. I think the difference is probably, and I think this might have been where the questions yesterday arose from, that wasn't shown on plan and map. per se, and so that's also been clarified through the attachments that Mr. Vivian provided, but that's consistent with the zones that are stored in the application in terms of that. We've already talked about that future growth area, so there was also a question around in the business zone policies, what was meant by high quality.
Yeah.
So the only thing I wanted to add to that was that I think that the answer to that question could also be if you read that in conjunction with the rule and the reason for the rule which are implementing that policy, I think it provides a bit of guidance. So when it's a restricted discretionary activity from the buildings
Right.
in that area, and the matters of discretion include building design and external appearance and landscaping and some other matters. But I think, and then in the reason it talks about being greenfield areas appropriate to control the nature, scale and look of buildings to ensure the sustainability of high quality development which will appeal to the wider community and residents. So I think that read together with that explanation and the matters of discretion, I think it gives it slightly more flavour as to what's meant by that.
Thank you.
So that was everything that I wanted to comment on.
Okay. Probably the only one you may not have touched on is, or reconfirmed, is the Cromwell Spatial Plan. There was a bit of a discussion on that, and you've addressed that in your paragraph 53. And I note that the Cromwell Spatial Plan intends that growth is concentrated and consolidated within the existing urban area of Cromwell Township through high density development. And so we've heard that the master plan doesn't address this site, doesn't address Parkburn at all. But I guess I was just going to ask whether you had any further comment on whether the fact that it's not within the boundary of the spatial plan, but there's an intent to consolidate. Does that by inference mean that there shouldn't be satellite growth? Did you see it that way or not?
The way that I read the spatial plan is that it is focused on, I guess, providing for the additional demand in sort of the current Cromwell urban limit. So there's some, I guess, infilling in terms of greenfield in that area, but also in terms of intensification. And that the spatial plan essentially said that's where growth should be focused rather than expansion of the satellite areas. But that, I guess I wasn't involved in that, so it's hard to know how much that was specifically considered. Similar, I guess, concerns came up in the plan change 19 process around Bannockburn,
Right.
where there were a number of submitters who were seeking rezoning of that area, and a similar issue with, so both in Bannockburn and in Paisley Moorings, there is localised demand that would not be met through the existing zoning, and therefore there's a reliance on that demand would have to be met effectively somewhere else.
Yeah. No, thank you for that. And we certainly heard a lot of other reasons why this proposal doesn't offend the master plan. So that that's the question of use, just on that one aspect of it. So thank you for clarifying that.
With regard to the NPS HPL, you've in your section 42A, you've addressed the NPS HPL thoroughly there, and you sat on the fence a little bit in terms of where you think the application of that. We've heard from legal counsel and SAWS expert yesterday, and also Mr. Vivian, on kind of how the interpretation and application of that national direction. Do you have anything further to comment on that?
So my view is aligned with the Mr. Paper's submissions. I think what I was conscious of in sitting on the fence is that I'm aware that there is proceedings challenging that, and so therefore I didn't want to suggest that just because I have a view that that there was a wider context to that. So, yeah, I think it seems a little bit of a nonsense to me that if you cannot challenge that border. I mean, what I understood Dr. Hill's evidence was that it's based on this higher level thing, so therefore, and things have changed over time, and so therefore, when you get into the more site by site analysis, using the same classification system, you can find that it's not accurate, and it seems to me that it would be a bit of a nonsense to not have the ability, I guess, before the regional council does the mapping, to be able to identify instances of that and say, well, this is clearly not what the policy statement is actually aiming at. But yes, I'm just conscious that might not be, that's not necessarily what everyone's opinion is of magnitude of that concept.
Sure, thank you. So I noticed in your statutory appraisal, you've not specifically considered the NPSHPL, but what you're saying is that the proposal is not in conflict.
I don't think so.
Okay, great. Thank you for confirming that. My other question was around rabbit proofing. We heard from the submitter yesterday, and Mr. Vivian's assessment matter, he adjusted it slightly from what you had recommended. What are your thoughts there?
I don't even know what Mr. Vivian is suggesting, because it essentially spells it out. But potentially, because this is very specific for the site, and that is the main issue here, I don't think it would hurt to mention that, but if you were to do that, I think it would retain Mr. Vivian's wording, but just say including rabbit proof measures, just to the avoidance of doubt, and that would really only be because it's obviously already included, but it would just be that if someone comes to apply subdivision sometime away and everyone at the council is different for those who have been involved in this process, and it just informs of that sort of.
Yeah, sure.
Island.
Thank you. And in relation to the submitter's presentation yesterday, having heard that, are you any clearer around the rabbit stop request? Rabbit stopping?
No, what I understood from the presentation yesterday was, and I'm not sure, but I think was in essence making sure that as the area is developed, that there are stops used either as part of the staging of development and or making sure that you're effectively in the new urban, what becomes the new urban area, that you have the same measures coming in as you currently do. So I was slightly confused, I think, by the original submission that saw this, as I understood it, was seeking that almost some measures within the urban area. But I think if I understood correctly from yesterday, that was more, I think, in terms of potentially this at the development stage.
Yeah, sure. Okay, thank you. That's everything I have. Thank you.
Okay. Ian, did you have any further questions? Just one question I possibly should have put this Mr. Vivian as well, that through the course of this plan change process, there's been some refinements, I could call them. I think the refinements made in response to submissions, and also the JWS has introduced some new provisions. Are you able to comment on whether those are within the ambit of, would require a 32 AA sort of evaluation, because they've changed since notification, without sort of going through and looking at each one in turn? Do you have a feel for whether those are refinements that are within the ambit of 32 AA?
Yes, I think they are, because the 32 assessment, I suppose, was more fundamentally concerned with the rezoning.
Yes. Okay.
Of the site, and these are more, I guess, narrowing down or tightening up things like matters of discretion or additional controls that are required to manage effects. But that fundamental question around, I guess, is the zoning more appropriate than the status quo? I think it's the case. What I can't remember is that I think the section really for assessment did include consideration of the additional provisions being added, but at that stage it was only the industrial and the business zone provisions. So possibly I think section 32AA might be required with respect to the additional
Residential chapter.
residential
Yeah.
provisions.
Mm. Yeah, that just occurred to me now. So yeah. And if you've got any comments in relation to the other chapters, sort of apply to that as well. And while a 32A may be required, there's other changes that are proposed to the residential chapter, generally within the scope of, you know, narrowing things down or adding new controls. Is that with it? Have you got any comment on that? I guess is what I'm asking in terms of 32AA.
I mean, I think ultimately what was sought by the plan change was the application of residential zoning to the area.
Yes.
And the additions to the chapter, I think, are about some more specific considerations or restrictions on that
Yes.
to address these.
Okay.
But some of those, I think probably there is a need to examine them in terms of 32AA, just with respect. So, for example, the traffic, the rules that relate to managing the effects of traffic obviously are about better achieving the outcome sought in the plan in terms of the safe and efficient functioning of the road. So to me, it's sort of a no-brainer that it's a more effective way to achieve the outcome sought by the plan, but still within the ambit of essentially the main assessment being about is residential zoning more appropriate.
That's right. Thank you for that. Got no further questions, but yeah, I guess for the proponent, that's something that the panel will have to address, and ideally we would like you to comment on that so that we've got something, you know, we've heard from the officer, but there are changes to a chapter that weren't proposed as part of the notification. So yeah, we will need to address it in our decision. So if you can help us with your assessment of 32AA, I don't think it needs to be an in-depth assessment, but certainly some comment on that and from Mr. Vivian would be useful as part of your reply, if that's okay. Part of your closing, I should say. All right. Thank you very much. There's nothing else we've got for you. I've had a number of questions that have all been scrubbed out, so thank you very much. So we're now at the point where we'll just go back to Mr. Page and just see how you wish to proceed with your closing.
Well, there are some things that I want to address with you orally.
Yes.
Which was likely to give rise to you getting that you filed.
Yeah. No, and I think yeah.
Submission with some updated documents.
I do prefer that anyway. Yes.
Yes. So, in terms of your obligations under section 32, capital A, for example, I'd rather deal with that in writing than on a hoof.
Sure. Yeah.
Because
sure.
On the face of it, you're required to evaluate any changes to the proposal under section 32. Yeah. But on the other hand, only at a scale that is commensurate with the significance of those changes. So exactly. Changes are insignificant, and so is the analysis.
Yeah.
Anyway, that said, it's important that if you have anything that would assist you to discuss with either Mr. Vivian or any of the other witnesses for that matter, that you have the opportunity to do so while we're here. If you want Mr. Vivian to join me now, we can do that and establish dialogue on things that are occupying your mind. The only matter of reply that I wanted to address you on orally now is the question of what we do with the PBDL land. So I'm happy to do that now.
Yes.
And my submission, you'll recall when we opened yesterday, I said that Fulton Hogan as a proponent didn't really have a view one way or another about the scope for including adjacent land. That remains the view But in relation to PVDL's land, something occurred to me during the course of a hearing from Mr. Barr, which I think is important. And to understand that, we need to go to the Parkland and Structure Plan. The easiest way to do that is to have a look at page 743 of the materials that Mr. Murphy handed up this morning. And so what that does is delineate what the Parkland Structure Plan area is. And you can see down at the southern boundary, there is a parcel that's not identified as the PVDL land, but you can see what it is. And you can see that the connection to Pony Court is shown on the structure plan. So I'm inclined to agree with Mr. Barr that because a connection through PVDL's land to Pony Court is part of this proposal, and is now an assessment matter following the JWS, then I think PVDL are home free saying that there is scope for considering PVDL's land. But that then leads to the question of how. And my submission to you is that you can't be half pregnant on this plan change. You're either in the structure plan or you're not. Because that's the method that this plan change brings forward, as it creates a structure plan as a way of managing the layout effectively of the zone. So it seems to me that if PVDL are going to be in on this plan change, then they should be part of the structure plan and shown to be part of the structure plan. And the importance of that is demonstrated if we go back to page 718 of the revisions. And you will see where the structure plan rule has been inserted as an assessment matter, clause 18. It defines what those assessment plans are within the Parkland area. It tells you what the structure plan is and where you find it. But importantly is C, measures to ensure the development of residential activities proceeds in the south-north direction. The internal road connection to Pony Court is formed, if legally possible to do so. Now, in terms of legally possible to do so is there, because unless and until there is an enforceable way of bringing Pony Court and in particular the PVDL land into reckoning, that's beyond Otago's control. But of course, if the PVDL land is brought into the structure plan and PVDL is required to create the connection to Pony Court to the structure plan land, then that problem's solved. So in a way, bringing the PVDL land into the structure plan is quite an adequate way of solving the problem. And if that were to occur, that would head off past the problem that Mr. Barr hinted at when he said in answer to a question from Mr. Chairman, he said the site has existing frontage to Pony Court. It could be developed without the structure plan. Now, if you just stop and think about that for a wee moment, if the PVDL land wasn't part of the structure plan and it was subdivided in advance of the Fulton Hogan land and sold on to third parties as sections, the ability to create that connection through Pony Court disappears entirely. So that's a problem that you can fix by bringing that land within the structure plan.
And there's no concern about the discussion we had about the triggers, and the proponent would be comfortable with the cap being invoked.
Well, I mean, Mr. Barr's evidence was that the site has a yield 7. I don't think that's calculated, but let's take that as gospel.
Okay.
So there would need to be a consequential amendment to raise 271 to 278 as the first step, and then the maximum from 543 to 550. And as I understood Mr. Smith's evidence yesterday, he didn't think that was material in terms of his modelling in relation to the trigger points.
Waku Kotahi. We haven't heard from them on that. They haven't turned their mind to it, at least.
Well, that is true. They haven't turned their mind to it, but on the other hand, they haven't participated in the hearing, where all sorts of things generally happen, and parties need to take part in it if they want to. So,
all right. Okay. I mean, one option for the panel could be to, I'm just talking off the top of my head now, but could be to ask that question, because Waku Kotahi have invited us to ask some questions, and we've said we haven't got any, but they could be put to them. But we would wait for the written right of reply to relay that to.
Yeah. So what I propose is in the written right of reply is that we prepare an amended version of what Mr. Vivian handed up this morning, which shows the PVDL land in the structure plan and the amendments to the triggers.
Yes. Okay.
So that you've got that there.
Okay, and it might be useful to have Mr. Smith's a brief comment from him on that, because I think we heard from him, but it would be useful to have it captured in writing too.
We could ask him to provide statements. That makes any difference.
All right. Okay. Oh, sorry. You got a question, Mr. Barr?
Excuse me.
Yeah.
About taking Mr. Tatum clothing. I just noted the words was what witness conference between planners, which was perhaps late notice.
Yeah.
But I was kind of wondering why I wasn't invited to participate, given that I filed evidence as well.
Okay.
So perhaps the way to get through that would be given an opportunity to answer some questions or provide some feedback on those provisions before closing. It's out of step with the process, but it might be an efficient way to fit in the ability to provide some more meaningful advice on the provisions and how they might fit with especially if the PVDL's land is bordered with the structure plan.
Right.
And there's overall yield numbers on the overall yield of the plan change, and also there's a trigger rule in terms of roading upgrades as well.
Right. Okay. I'll have to then I might have to take time to consider that request. Yeah. We'll consider that and take a brief break to consider. And Mr. Page is welcome to respond to that too. So then you interrupted his flow, but yeah.
Well, we want to get to the best solution.
Yeah.
Speed isn't necessarily a priority. I need to think about that. Yeah, and just to clarify, the panel had no role in directing that JWS, by the way. So it came in very late in the proceedings, and we didn't direct the JWS take place. No. But that's why I'm not in a position to answer you on why you weren't included. That's all. But I'd need to just consider what the purpose of the planner's JWS. Did that include traffic engineers as well? Is it just it did? Yeah, it had a specific purpose, didn't it, to resolve the fact that Waku Kotahi wanted to file late evidence on transportation matters, and I think the initiative was taken by those participants. So it wasn't a direction of the panel that all planners be involved in that. It was specific related to transportation. But perhaps, sorry to interrupt you, Mr. Page, but just to deal with this now, if I could just ask you what you would envisage coming from that, Mr. Barr, what would be your what would you be asking for your client in relation to JWS?
Just what comes to mind is that if there was a conversation between other planning witnesses as to trigger rules and overall yields, if the submitter, your expert, had an opportunity to have a look at those provisions and how they now work, that land needs to be part of the structure plan, and also what sort of obligations there were for any subdivision development as part of the structure plan.
Okay. Again, I can't give you an answer on the top of my head. We'll have to consider that. But you formally requested, what is it you've requested that you?
Just the opportunity to provide feedback on the draft provisions and recommended provisions on the basis that PVDL land would be included in the structure plan.
Okay,
It might be as simple as just making sure that the estimated yield from PVDL's land is perhaps included in the overall numbers in the rule framework.
because I see, because that's what's being suggested by Mr. Page, isn't it, to add those on? So are you saying that you would be comfortable with those figures being added into the yield?
Yes, but I just like the opportunity to make sure that the numbers add up.
Oh, I see. The numbers add up. Do you mean whether the 7 is the correct number?
Yeah, that's right, because it was 7, in addition to what's already zoned, so the actual number is about 15, for the interior residential.
Right.
That's what's amazing.
Oh, I see. It's 7 additional units.
Yes,
Okay.
that's right. You can
I
just
see.
about-
That's where the 15 came from.
Mm.
Okay, I see. So, all right. Do you understand, Mr. Page?
Yes,
Yeah,
I do.
it's a bit of a dialogue, sorry, but it might help us. Yes.
Portland doesn't care what the number is, whether it's 7 or 15.
Right.
Number.
Okay.
The basic proposition is, that's not a number that comes off Portland's yield.
No, that's right.
And I think Mr. Barr understands that, but talking to agree with that moment ago.
All right. On that basis, Mr. Barr, is there any value in us just recording that, what you've just said then, in the sort of agreement, I guess?
Well, I think you should report what you've just said, and also I even included the operative yield.
All right. Yes.
And the potential maximum yield under the loading to residential zoning, and the difference of about 7.
Yeah, it's probably timely that you've told us that, because in communications with Waka Kotahi, we'd need to relay that to them, that the 15 was derived from existing yield, which could happen regardless under the current zoning, plus another 7 if it was rezoned to high density. Yeah, so thank you for that. I don't think we need to reconvene the planners or anything on that basis. So thank you.
No, thank you. Thanks for leaving me here.
All right. Okay.
Anyway, so just to circle back to the basic proposition that I was advancing is that if the PVDL land is to be part of PC21, then it needs to be wrapped up with the same provisions that apply to PC21, rather than it being a planning island.
Yes.
Because if it's to be treated as a planning island that's not part of the structure plan law, the rest of it, then that really raises a question mark about whether that submission's on plan change at all, or whether that's just an opportunistic exercise. So.
Right. And just before you go off that, I noticed that figure we were looking at, which was it 743. There doesn't seem to be a hard line on the south boundary to what the structure plan area is. I know it shows Pony Court, the dotted line, but there doesn't seem to be a hard line. Could that be an improvement, do you think?
I agree with you. I think there should be a way that delineates the cadastral boundary of the plan change more clearly. So I think that's a improvement that could be made.
Make a note of that. Thanks. Yeah. Very good.
All right. I really don't have much to say about the HWR submission on the north boundary. We don't have a proposal for rezoning the land on the side of the boundary to chill on, or an assessment of it. Alden Hogan's approach has been, well, we only can deal with what we know, and that's what we've done. So, for example, the integrated transport assessment that was done didn't include the HWR land. Got no idea what connections to the state highway they proposed and how that's going to work. So, whilst we're sympathetic to what HWR are trying to achieve, my submission we're a little early. In the event that there is a future plan change for that land to the north, and that rethinking how the Parkburn plan change works in conjunction with that, that's the time to deal with it. I don't think the time's now. The only other matter that I wanted to respond to was the PC21 and PC19 conundrum.
Yeah.
and that you're likely to have your recommendation through before the 19 is through. My submission, what would happen at that point is that having supplied your recommendation to the council, it then becomes for the council to supply that recommendation to the PC19 panel. And the PC19 panel would then be tasked with how it addresses that outcome through PC19. If that was the sequence first, and if that didn't happen for whatever reason, then Fulton Hogan as a submitter on PC19 would be able to file your decision on PC21 with that panel and invite them to deal with it through their decision.
Right.
But, I mean, the council has obligations under the section 31 of the Act to achieve integrated management of resources as part of the statutory function. So integrating those two plan changes is a core planning function in the council.
Yeah, thank you for that. So I think earlier I'd given you the scenario, it would be a draft.
Yes.
What you're suggesting, it should be a final, it should be an actual decision that goes to council before it's issued. And they would have a final recommendation from this panel. And then they deal with 19 and potentially release them both at the same time. Because that would be integrated.
Well, I'm slightly at sea about that because that depends on the nature of your delegation.
Yeah,
Your delegation is to actually make the decision and to notify it.
yes, that's right.
Then the council doesn't really have a statutory role to play in that.
Yes,
If your function is to make a recommendation and the council then either adopts that or not and notifies the outcome, then there's much more wiggle room about how that process works.
Yeah, no, that's correct. And I think our recollection is it is a delegation to make a decision, but I'll have to check that, of course. It's been some time. Do you understand that position? We've been asked to make a decision, not a recommendation. Yeah, you don't know.
Yeah.
We'll check on that. But obviously, if it's a recommendation and not a decision, then it will go to them as a sort of almost a draft.
And there may be other ways of skin that can too. You can issue an interim decision saying these are our findings on the evidence.
Yeah. Okay.
And if the PC19 would form part of the plan by the time you make your decision, then our decision would be expressed in those terms. So
yeah. Okay. No, look, I understand that. That makes sense. Thank you. Yeah, that's right. So we have got delegations to make a decision on this one. Yes.
Yeah.
Yep. Yeah, very good. That's what we suspected. Okay. Very good.
all right. Well, unless there are other things that I can assist you with at this point, I think the next task for us is to prepare a written final closing the updated provisions that
Yes.
deal with the PDDLA.
So there could be another iteration of provisions. Mr. Vivian will be delighted about that.
I mean, it's really a matter for you in a way, in the sense that
Yeah.
if you were minded to say, look, we're not interested in incorporating PDDL into the process because it just complicates life, then that's a merits decision.
Oh, absolutely.
But in the event that you do
Yeah.
decide
Yes.
that you want to accept the submission, but
Yes.
it has to be part of the structure plan, and you're going to need some updated provisions.
Absolutely. Yeah. And we are interested in the comments on 32A that we talked about earlier. We certainly will benefit from a written reply. So thank you for doing that.
We'll deal with that later. Right.
Okay. I think we're almost there. We're not actually going to close the hearing, we're going to adjourn it, but I'll just do a closing karakia. Kia hora, tu marino, kia whakapapa punamu, te moana. And I'd just like to thank everyone for their involvement and participation. There's been a lot of work being done at short notice on some of these provisions, and the panel greatly appreciates that. So thank you, everybody. We'll adjourn the hearing. Thank you.
Thank you.